So first of all, we're going to be going through and just describing a whole bunch of key terms that you need to know. And this is all about being able to understand things and describe them using legal terminology. So commissions is the first thing that we're going to look at. So at the federal level, the Australian Law Reform Commission has the function of reviewing our laws and making recommendations to the federal government on what should change about the law. And at the state and territory levels, this role is the responsibility of a whole bunch of different state and territory law reform bodies. So in Queensland, we've got the Queensland Law Reform Commission. Now, law reform also occurs through royal commissions of inquiry, and we'll have a look at those as well in more detail. So a royal commission is a government inquiry, and it's established by the Governor-General, and the role of these inquiries is really important to address the sort of key issues that are current in Australian society. Oftentimes the findings and the recommendations that result from those end up producing some important law reforms. So we'll have a look at some examples today of different law reform royal commissions, that have occurred, but different big events that have happened often result in a royal commission. Now, a parliamentary inquiry is an investigation by a parliamentary committee, so a group that is comprised of members of parliament, into an issue of political, social, or legal interest. And advocacy is any action that speaks in favor of, recommends, argues for a cause, or supports or defends, or pleads on behalf of others. It can be written or oral. Now, that is a bit of a mouthful, but basically it's that idea that you're advocating for something, you're supporting something very outright about it. So you can think of advocacy as being something that is really small. So, for example, your parent might advocate for you in terms of school. Maybe they're advocating for free tutoring or something like that. And then advocacy can take place on a far greater scale as well. There can be advocacy groups, different corporations, and just organizations in general can form together to create these advocacy groups. And there's lots of just individuals as well who form groups to support different causes. And oftentimes we also see groups like this forming to be a voice, I suppose, for people who don't have one, or for people who are less kind of powerful. So, for example, when we think about things like refugees and that kind of thing, we have different advocacy groups who try to support people who are wanting to get entry into a country, to get their visas sorted out, that kind of thing. Okay, so law reform. Now, this is kind of a three-step or three branches, I suppose. So it can be changing existing laws, it can be repealing existing laws, so removing them entirely, or it could be just creating new laws as well. So when we think about the kind of formal definition, it's the process of examining existing laws and advocating and implementing changes in a legal system. So the aim is usually enhancing justice or efficiency. So it can be because society's beliefs or values have changed, or there's some kind of inequity in the existing laws, so they need to be changed or repealed. And you could also have new laws entirely because there are new factors that come about as time goes on. So technology is a really clear kind of example of that. and that can result in new laws being necessary. So the modernization of the law by bringing it into accord with current conditions, getting rid of any defects, simplifying it as well, and the adoption of new or more effective methods for the administration of the law as well. So there's lots of different aspects to that. It's not just about changing things, it can be about new things entirely, but the overall aim is improvement in general. So an example of law reform is when we think about 2022, there was the data breaches. So we had Optus and Medibank both had the data breaches, and there was actually law reform, I suppose, after that, because we had some new legislation that came through about data. So it was making it so big companies had more of a responsibility to make sure that any data that they do collect is protected well. So that is an example of how, I guess, technology and what people are able to do in terms of hacking or sort of invading the sort of systems of big companies like that have lots of data, that has resulted in those laws being necessary. Now, lobby. So, according to the Lobbying Code of Conduct, lobbying activities are communications with the Australian government representatives in an effort to influence federal government decision making. So, if you're lobbying the government, you're trying to get them to be aligned with what you want and your values. You're trying to influence their decisions in some way. So you could be looking at getting a government contract or a grant. You could be looking at the way they allocate funding or the way that they're amending legislation. It could be a government policy or program. Any of those sorts of things that are of interest to a lobby group, they can try and influence the government's movements around those things. So a lobby group is an organized group or association that attempts to influence those legislators to achieve that desired outcome. And there are two different types of lobby groups. You've got sectional lobby groups. So that's a self-interest lobby group like a trade union. And promotional lobby groups. So an organized group promoting a particular cause. And like advocacy, it's pretty closely related to that, but it's more about government decision making, because you can have direct and indirect lobbying. You could be sending letters or having meetings with the actual members of government, whether it's the local level, the state level, or the federal level. Or it could be more indirect kind of lobbying where you are trying to bring awareness in general to other people, maybe not communicating directly with the members, but maybe their staff or something that's slightly more indirect like that. Utilitarianism. So, this is a system of thought that states that the best action or decision in any particular situation is the one that brings the most advantages to the most people. So, the most benefits, I suppose. And an example of how this can go wrong is the 2009 home insulation program from the Labor government. So this definitely had this idea of wanting to bring the most benefits to the most amount of people, but it wasn't executed in a way that worked, unfortunately. So in 2009, the government announced this program, which was going to it was aiming to stimulate jobs growth and encourage homeowners to reduce their energy consumption. And so homeowners were able to receive funding to have this insulation installed. But because inexperienced workers were managing the process, there was a few deaths. So 4 installers died because they were electrocuted, and this actually resulted in a royal commission as well. And so it had good intentions where it was supposed to be stimulating jobs and helping with that sort of sustainability aspect with energy consumption. And sometimes it's pretty hard to get both of those things. So this was bringing lots of advantages to lots of people, but unfortunately it did negatively impact some people. Now, throughout today's lecture, we've got some questions to get you thinking about what we've discussed and to act as a little bit of revision for you. So as we said earlier, the unit that we're talking about today, you'll be doing an assignment for. So you won't be needing to memorize things for an exam, but you can still have this idea as kind of something to revise. You still need to understand these things. So the questions that I've got throughout this slide deck will hopefully help with that revision. You can go through it later and try and see if you can answer these different questions without looking at all of the resources. And I encourage you as well to pause the video as well and see if you can answer these things before you move on to the rest. So the first one is describe law reform. And something that can be handy when you're thinking about these things is try to think of an example as well. So it can be tricky to remember lots and lots of different concepts when it's just a whole bunch of words that are perhaps not familiar to you, lots of different terminology. But if you try and remember real world examples that we talk about today or that you can think of yourself, that can help you remember the different concepts that you may otherwise not be able to keep in your mind. So, for example, that one we just spoke about with the home installation program may help you remember utilitarianism. Okay, next up is terms of reference. So the scope and powers of an inquiry. It's just laying out what is going to be investigated as part of this investigation. So in terms of Royal Commissions of Inquiry, we've got a process with 8 different steps here. So first of all, the government is going to request the Royal Commission into a certain topic. Then they go and decide what the terms of reference will be. We've got a commissioner being appointed as the chair. Others can be appointed to work with the commissioner. Then you've got a whole bunch of evidence gathering, so witnesses are heard, and then the findings are decided, recommendations are made, and the report is created and given to the government. So to start with, it's very early on in the piece that those terms of reference are laid out, because then that informs the rest of the process. So because it's determining what the scope and the powers of the inquiry are, it's going to determine who is, what kind of evidence they want to gather, what kind of people they may approach to try and get some evidence, and also the kind of commissioners or the kind of people that they get involved in the process, depending on the sort of topic that they have chosen as their inquiry topic. So here is an example of all of those steps laid out with an example alongside it. So in 2012, the Gillard Labor government announced a Royal Commission after public pressure and allegations of a police officer in New South Wales. So this Royal Commission was into institutional responses to child sexual abuse. So you can see how we've got the government calling that inquiry, and the next step was them determining those terms of reference. So in this case, they wanted to inquire into and report upon responses by institutions to instances and allegations of child sexual abuse in Australia. So you can see how the kind of wording in that is giving us that scope to go by. So it's responses by institutions. So that's sort of narrowing down the focus. Allegations of child sexual abuse is narrowing it further, and then also, of course, specific to Australia as well. Then you've got different commissioners being appointed. You've got a whole bunch of witnesses being heard. So the terms of reference also influenced this. So witnesses reported on events that occurred in Scouts Australia and lots of different other organizations that knew about this area. And then you had lots of recommendations, 409, and then the final report being presented at the end in 2017. You can see how it's a really long process over more than 5 years in this case. Now, consultations. So the Australian Law Reform Commission conducts research and consultations with stakeholders. And by talking and listening to people, it can understand different views and experiences of the law. So, of course, everyone has different experiences, different opinions. So, commissions like this need to seek a whole bunch of different information so they can actually understand those things, because they otherwise wouldn't be able to. So they want to consult with people not only who have expertise in the laws under review, so maybe they've got some kind of law background, or they know about the laws on some kind of level, but it might just also be that experience with the laws. So maybe they've been negatively or positively impacted by the laws. Maybe they think the laws are discriminating against them or something like that. And it's also about people who are likely to be affected by the laws. So maybe they haven't been affected yet, but understanding what their experience would be if it were to impact them can also be helpful in these cases. So you can have a whole range of inquiry stakeholders, so government departments, courts, legal professionals, industry groups, and special interest groups, academics, and then other members of the community as well. Issues papers. So these are papers that are presented to an inquiry that detail the issues under investigation. So as part of these inquiries, lots of information is sought, and issues papers are providing some of that information as well to inform that inquiry. So they can provide information, data, and further explanations that would assist the inquiry and the reporting process. So you can see an example here on the screen with the Native Title Act, and you've got an issues paper on that. So the Indigenous Justice Clearinghouse, or the IJC, publishes issues papers and advocates for law reform on Indigenous justice matters. Now, this is an example of advocacy. They've got the kind of interest that they are wanting to support and advocate for, and they have that means of doing that. Their means is to create these issues papers. So submissions. Now, we've been talking a lot about how the Royal Commissions are going to seek a whole bunch of information, and one way that they can get information is through submissions. So any kind of public contribution to an inquiry. Now, anyone can make a submission. It's an open kind of system. And as part of an inquiry, a committee usually asks for written submissions addressing the terms of reference. So again, that idea of terms of reference, it obviously needs to be relevant. So those terms of reference are really important to show what they're actually looking for and make sure that they get the evidence that is actually going to support their decision making. Now, submissions are actively sought by the Australian Law Reform Commission from a really diverse sample of the community, as well as those with that certain special interest in the inquiry. And so submissions are really important because otherwise the government the Law Reform Commission is not going to know everyone's experiences. You need that diversity. Otherwise, it's not going to result in the fairest possible outcome for everyone.